I think most of you know me. I'm Frank Congelos. I'm the managing partner here at CNA Financial Group. It's our pleasure to have you with us today, and those of you who are online. Over the years, we have different topics that we talk about for our business owners and for advisors, just to keep them up to date on what's going on as it relates to how to protect our business owners. It's probably over 5 years ago that we met. And
Yes.
so forth through Sam Soprano. Everybody knows Sam, longtime advisor of ours, one of our leaders. And so it was our pleasure over the years to get to meet, Melinda and Vanessa, with regard to employment law, because it's one of those there's not a lot of people that really know what's going on. And normally at the time that somebody needs somebody, it's too late to try to figure out, well, who's good in this? And so it's our pleasure today to have the two of them with us today. And so when you just kind of look here, so Melinda is with us here in person. So welcome, Melinda.
Thank you.
HR Advantage Advisory. Princeton, but your home office, it sounds like, is Detroit.
The corporate headquarters is in Detroit. Yes.
And so just a wealth of knowledge in HR. And then Vanessa Kelly with Clark Hill, attorney. Just wealth of knowledge as it relates to employment law. So without further ado, welcome, and it's all yours.
Thank you so much. So Vanessa will be virtual with us today in this virtual world after COVID. Vanessa relocated. And so even though Vanessa is licensed in New York and New Jersey, she actually sits out of state. So Vanessa, I don't know if you'd like to say a few words to welcome everybody.
Yes, good morning, everybody. And, as a legal professional and HR professional, Melinda and I talk about being trusted advisors to our clients. And like we are trusted advisors, Frank and Sam and everybody at CNA Financial Group are your trusted advisors. So they're often the first stop when you have some type of problem, even employment law, which isn't them, but they can usually connect you to somebody. So you guys are all very fortunate to have such great trusted advisors in CNA, and we're happy to help support their clients that way. So thanks for indulging us this morning.
So we are going to cover a variety of topics today. Employment law is vast, right? There are so many different things that we could cover. So we did have to try to narrow it down. So we picked kind of some of the more common pitfalls for employers, particularly employers in New Jersey, because New Jersey is a very complicated employment law state. People often call us the mini California. And so if you're doing business here, God bless you, because it is complicated here. So these are the things that we're going to cover. Vanessa's going to start with the New Jersey law against discrimination and the Equal Pay Act, wage theft, and pay transparency. Then I'm going to jump in for sick leave and talk about the family leave in New Jersey. And then Vanessa's going to wrap us up with artificial intelligence. And if we have enough time, then we're going to get into some hypotheticals and test your knowledge. So make sure you're paying attention, because we're going to test you at the end. Vanessa, what do you want to add to that?
What do you want to do with questions? Should we take questions as we go, or we'll save some time, or what do you?
Yeah, maybe we'll save questions for the end. It's probably going to be easiest when we're split like this.
Okay, please, those of you who are online, you can put your questions in the chat, I think. And then there's also a Q&A button, I think, too. So I'll be monitoring the chat online. Okay.
So I think we want to start with a question. You want me to do that?
Sure.
Okay. So we wanted to ask people, and for those of you who are in the room, a show of hands is fine. For those of you online, maybe you can just put it in the chat. We're curious, how many companies here, or the companies that you represent, have between 0 to 10 employees? Raise of hands. All right, we've got several in the room here. And how many have 10 to 30? Okay, couple. And how many have 30 to 50? You're still raising your hand. Just one? Okay. Anybody over 50 in the room? Okay, over 50 employees. Good to know. Couple of them. And how about in the chat, Vanessa? How are we doing in there? People.
We had one person that raised their hand for the first category, and then another person who raised their hand for over 50. So.
Okay. All right. Good to know. Many of this will apply to all of you anyway, even if you don't have that many employees.
So life is full of surprises. And we decided to, that's our theme today, that life is full of surprises. Being an employer in New Jersey is full of surprises. So surprise number one, we talk about the law against discrimination, which is New Jersey's main anti-discrimination and harassment law. We refer to it as the LAD because everything in employment law has acronyms, EIEIO, here we go. So it applies to every employer, even if you just have one employee. So you are subject to it in New Jersey. And what the law says is that you cannot discriminate in any of the terms and conditions of employment. And it applies for the entire cycle of the employee. It starts with your candidates in the hiring decisions. It applies to promotions, your pay practices, discipline, your benefits. You can't discriminate in benefits, and sometimes people forget about that. And the discrimination is on any protected characteristic, which we'll get into on the next slide. And it also means that you cannot harass somebody based on that protected characteristic. So what is a protected characteristic? Well, some of them are obvious, and I think everyone, in America would know some of these. It's your race, your age, your gender. But some of them in New Jersey are just a little bit more particular. We cover gender identity or expression, unlike some states do not apply protection for that. Title VII does apply to gender identity or expression per the Supreme Court, even though the EEOC is not enforcing that provision at the moment. We also have protection for military service. You can't discriminate because somebody either served in the military or may be subject to military service, such as National Guard duty. You can't discriminate against somebody on a physical or mental disability. Everyone, I think, probably has heard against the Americans with Disabilities Act, but we have a state companion to that, which follows some of the same laws, but unlike the ADA, again, another acronym, it applies to just one employee on. The ADA, you have to have at least 10. So we have that. And it also applies to your marital status, familial status. So you can't discriminate against someone because they have children or caregiving responsibilities. So it's pretty broad, covers a lot of things. And then sex harassment. I think people have heard about sex harassment. The Me Too movement was very big several years ago, but it's still there, and sex harassment is still one of the most prevalent claims that we find being filed in either a state agency or in court. And it is a form of gender discrimination or sex discrimination that's prohibited by the LAD or LAD or federal statutes as well. And there are two main kinds. There's quid pro quo, which in Latin means this for that. So you are giving a benefit in exchange for something that's being given to you. And then the second form is hostile environment. So quid pro quo, I think that's the most blatant form, but it's also can be a little bit insidious. It would mean that you condition the receipt of employment benefits based on the person's willingness to submit to sexual advances or to provide sexual favors. So you would think that would just scream out at you, but it can be a little bit more subtle. If a person's in a position of authority, like you have someone in the C-suite and the person that is subject to this type of conduct is very junior or doesn't have the same power and authority in the organization, there can be that sort of subtle pressure. So even something that would seem consensual may not truly be consensual given that power dynamic. Who remembers the kiss cam incident? I think the guys were at a concert and, we saw the CEO there with not his wife, but, another employee. I think she was the HR officer, which really didn't look good. That wasn't a good look. But he, there was a lot of pressure and he resigned. Yeah, right. What concert was it?
Coldplay.
Oh, okay. Coldplay brings it out. What can you say, So I guess the message from that is don't get on a kiss cam if you're not there with your partner. But anyway, but the reason that, there was so much pressure for him to resign is because, the the enforcement or the how much authority and how much life you give to your employment policies really starts at the top. So if you have two individuals who are not living, up to the policies of your company and they're in management, senior management, that's really not good at all. So there was a lot of pressure, and I think both resigned. But anyway, that's one of the most prevalent examples of it. And of course, Harvey Weinstein and everything that he did was just horrible. And you can't believe people do that, but people do that. So anyway, that's quid pro quo. The more common type, which we see in our cases, is hostile work environment. And you hear that. People throw around that term, employees throw around that term. This is a hostile work environment. My boss actually wants me to get my job done, and he calls me 3 times to follow up on it. That's not the hostile environment we're talking about. We're not talking about just you feel it's hostile because there are certain expectations, or maybe you don't have a great supervisor because they're, a shouter or whatever. And that may violate some other policies. That might violate your code of conduct, but it doesn't create a hostile work environment that's protected by our LAD. Here we're talking about the conduct has to be focused because of one of those protected characteristics, not just gender or sex, but it also applies to race and age and all the other protected characteristics that we went through. And what it means is that there's some conduct that's being directed to the person, either of a sexual nature or related to that protected characteristic, that is offensive and unwelcome to the individual as measured by a reasonable person, a fictional reasonable person standard. And it's either severe or pervasive. Severe meaning it was just an egregious response. I tell clients, if you have someone saying the N-word in your workplace, that's enough. Just one instance of that. That's a severe example. Or pervasive, meaning that it's happened frequently. It happens over and over again, and over a period of time. Even maybe it's like once a month, but it's for 12 months. That can be enough to be pervasive. So that's sex harassment, and that's your first surprise.
Vanessa, before we go off of that, do you have to conduct annual training for harassment in New Jersey?
You don't, but of course we think that's a best practice. We think that, you should have your policy in your handbook. You should train your managers and your supervisors, especially on this. And, your regular workforce should be trained on it as well. In New York, it is mandatory, but in New Jersey, it is not. And the LAD has a retaliation provision. And what that means is that if a person has reported a concern about harassment or discrimination, you cannot have them be subject to any type of adverse employment action. And that would be, a demotion, they don't get promoted for something, their performance review is bad, they get subject to a PIP, and of course, the worst would be they get fired. And it also can apply to people that may participate in an investigation of a complaint. So someone complained to you about harassment, you did an investigation, it involved like talking to 5 coworkers. Those coworkers are also protected against retaliation. And there has to be a causal connection. And Melinda makes fun of me about this because it's the but-for connection. But for, we would not have retaliation. So there you do have to show that there's some connection between the reporting or engaging in what we call protected activity and then the adverse action that follows. And the courts give us some trouble here because the causal connection, you're not always going to have an employer saying to the person, you're getting fired because you complained about your boss harassing you. No one's going to say that. But the courts look at sort of temporal connections. So did the person get fired in close proximity to when they made a complaint? So when you talk to an HR professional, or you talk to an attorney and you want to talk about terminating someone, we will ask those kinds of questions. Has the person reported anything? Have they been out on a leave? Have they are they disabled? We will ask a series of questions because we want to make sure that the protected activity hasn't occurred so close in time to any type of event like that. And yet there is a defense. You don't always have to, you're not always subject to it. If the person making the decision to fire didn't happen to know about the protected activity, they're removed from it, and they had no idea, or there's a legitimate reason for it. What we also see in practice is an employee knows they're on their last rung there. They know that they've been spoken to about coming in late every day. They didn't get a good performance review. They know that their time is limited. And then all of a sudden they start, complaining about something. I'm not saying this happens all the time. I'm a little jaded because I've been doing employment defense work for 30 something years. So I fully have a bias on this, but many times concerns are legitimate, but we're talking about some instances where it's not. And so the legitimate reason for firing them was in the works before they complained, and was unrelated to any complaint. You still have to investigate the complaint, but we knew that they had been a poor performer. It was documented, they were spoken to, and there's your legitimate reason. So that's when we talk about having appropriate documentation. That's why. So.
And what do we say? We say document, document, document. It's that important. You'll never hear it less than 3 times, especially from an HR professional or an employment attorney.
Right. And the other thing we say is, if it's not written down, it didn't happen.
It didn't happen.
And I still say that to clients. What did you write down? Oh, then nothing. Well, you're not going to be able to prove this didn't happen. Okay, so surprise number 2. I hope we haven't scared you that you don't even want to hear any more surprises. But surprise number 2, what do we have, Melinda?
It gets better.
We have New Jersey pay equity, wage theft, and pay transparency. So in New Jersey, we have some of the most robust protections for an employee's wages in the nation. We have the Diane B. Allen Equal Pay Act that was named after a retired state legislature who was a big champion for pay equity and women's rights. And this really was a truly revolutionary pay equity, because it didn't apply just to gender. Many of the pay equities just talk about, disparity between male and female wages. This one applies to all those protected characteristics. So it applies to, race and age and familial status and all of those things. What it says is that you have to pay equal wages and you have to pay equivalent benefits. And sometimes people get hung up on that, where individuals are performing substantially similar work. And we're not talking about, do they have the same job descriptions? Are they at the same, band 2A or whatever your company is using? But is the work really substantially similar? And in some small companies, you might not have formal job descriptions, and in smaller companies, people do a lot of different things. So you're going to, really have to dig in and see what employees are doing on a regular basis, what's part of their, their typical day, what responsibilities, and are those similar? And then you have to pay them the same. And it's going to require the employer to justify what's the basis for that difference. And you can provide a defense to that, but it is going to be enough if there is a difference between a man and a woman doing this substantially similar work, and they're getting paid differently. That's going to be enough for the employee to go to court and then put the employer on the heels to then provide a defense. Again, there's this anti-retaliation that really is a provision that applies to most of our employment laws in New Jersey, because we want to encourage employees to come forward with concerns. And I think most people know now we can't stop our employees from talking about their wages with each other. But I know when I started doing employment work, that's what we used to put in handbooks. No, you can't talk to anybody about your wages. That's private. And, it can stir up a lot of trouble when you find out somebody's making, more money than you are and you're doing the same job. But, these statutes are the reason why they permit that, because you shouldn't be paying somebody the same wage if they're doing, the same job. So, that's sort of what we should be thinking about. You can't prohibit your employees from talking about it. Next slide. And it would be nice if we had a definition in the statute. That would be nice. That would make it easy to apply. Everybody would know what they're doing. But New Jersey and most statutes don't really tell you what is substantially similar. So you're just going to have to really, use your head to look at. It's a composite of skill, effort, and responsibility required for that work. You can pay people differently based on, some legitimate reasons, such as a legitimate seniority system or merit system. And you can, you're going to have to demonstrate that the difference can be accounted for by some legitimate reason, like, education or experience. There's a difference between someone coming brand new into a role versus someone who's held that role for 10 years. So that is going to be a legitimate reason. So each factor has to be applied reasonably. It has to account for the entire wage differential. So it can't just be, they have this extra license and that gives them a little bit, but it has to really be the reason why this person's getting paid more. And of course, it has to be job related to the position or based on a business necessity. So if you are going to audit for any reason, your pay practices, we do recommend having an attorney help you with that so that you can potentially have that be a privileged review. Otherwise, what you've just, found out in your audit can be the basis of a lawsuit if someone knows you did an audit and it's not privileged. Okay, so we just said that that employees are allowed to discuss their salary. There's the National Labor Relations Act, and typically people think this only applies to unionized workplaces, but that's not true. There's Section 7 rights, which give all employees, regardless of whether there are unions there, the right to engage in what is called concerted activities. So that's activities where they're able to discuss with each other terms and conditions of employment, which is defined pretty broadly. So a term and condition of employment, of course, would be their compensation. So they can get together and talk about that. So that, is protected both under the National Labor Relations Act as well as the Equal Pay Act we just talked about. Wage Theft Act. This statute really has some teeth to it. And I'm surprised that I don't see more wage claims based on this, but hopefully there aren't any employee side attorneys out there listening in. But this Wage Act went into effect, and it bumped up the length of time that an employee can make a claim. So employees can go back 6 years to try to recover any discrepancies in their pay. The employee can receive twice as much of their unpaid wages, so 200% of their unpaid wages in what is called liquidated damages. Again, we have retaliation protection, and we have what's called a rebuttable presumption, meaning that if we don't keep appropriate records, which happens a lot, especially in small companies, and there's an adverse action taken against an employee, you may have an issue. And then again, here's this 3 months, 90 days from when someone makes a complaint. There's a rebuttable presumption, which is a little bit higher than what I was talking about, how courts do that look back. But here, there's actually a presumption that if you fire somebody within 90 days of them making a complaint about their wages, that the reason they're getting fired or they didn't get their promotion or whatever it is was because they complained. You can rebut that, meaning you can bring forward evidence, but basically what you're doing is you're starting from a deficit as an employer to try to deal with that. And there are fines and penalties that come with that. And this is the scary part. It can be imprisonment. This has some criminal teeth to it as well. And then of course, every subsequent violation, the numbers go up. So, look, sometimes people legitimately make a mistake, a clerical error, things like that. So, if you do find yourself, subject to a wage and hour audit or a claim that's, filed, it does help to have an attorney work with you on it, because if you have been acting in good faith, then that can help you avoid some of your penalties, and they can make that, argument on your behalf. Pay transparency. New Jersey has joined the growing list of states that require you to disclose for your hiring needs what the range of the salary will be, and to give a general description of the benefits. So in New Jersey, it's where there's 10 or more employees over at least 20 calendar weeks. For businesses that are located in multiple states, if you have 10 or more employees total, but at least one in New Jersey, you're going to be subject to the act. If you are an out-of-state employer, but your reach of the job ads may extend to New Jersey, and you may likely hire someone from New Jersey, or conceivably could hire somebody from New Jersey, you're going to be subject to the act. If you regularly contract with businesses in New Jersey or sell to New Jersey businesses, that out-of-state employer is going to be subject to it. So it's got a pretty broad reach, and it covers not just like new hires, but it also includes promotions, your internal postings, and basically you're going to need to give the range, whether it's hourly or salary, general description of what the benefits are, because it's really hard sometimes to give the value of what the benefits, but generally, you would put in what the benefits are. Please put in also that it's subject to be, modified at the employer's discretion, so you're not stuck and locked into always providing these same benefits, because we all know insurance premiums rise for these benefits. And then any other compensation program. So if there's, a incentive compensation bonus program, you're going to want to put at least reference that that's there. And then, it covers any format of your solicitations for either promotions or new hires. So that would be if you're using one of these job search websites, Indeed, it's going to apply on LinkedIn. Sometimes employers put stuff on LinkedIn just to see who in their network does it. Print newsletters, your company newsletters, email, your social media, any of that. So if you're thinking about hiring and you're going to put it on your Facebook page, you're going to have to include this transparency. And of course, we've always had that well, not always, but we've always not been able to talk about the, what did you make before you came here? So you're going to not have those discussions, what was your prior pay? But, this transparency is going to make you really be intentional about what you're going to pay employees. It used to be, and maybe still is, subject to individual negotiation, and some employees are better negotiators than others in coming in, but you're really going to have to give pause to just agreeing to a higher salary for somebody that looks like they're a great candidate, because not only is that going to throw off your equal pay analysis, paying the same compensation for substantially similar positions, but it's also going to affect your pay transparency, that you're, where's this range? So you have to really be intentional about what you're going to be paying. And then if you are going to deviate from it, why did you deviate? And if you did deviate, Melinda, your line.
Document.
Perfect.
The business reason for it.
You're going to want to say why you made the difference. This person has extra licenses, not only do they have their CPA, but they've got this, and this. So it's important. So we talk about having sharp teeth. I said that at the very beginning. So, there's a 6-year look back on pay equity and the wage theft. Under pay equity, I think wage theft, we said it was 2 times liquidated damages. Under pay equity, it can be tripled 3 times. There's a potential for punitive damages if there's been an intentional act, and fee shifting. So that means if the employee has sought to file a lawsuit based on pay equity principles, they can recover their attorney's fees. So not only are you paying your own attorney's fees, paying whatever judgment comes in, which can be tripled, but now you're paying their attorney's fees on top of it. So that's a big whammy. And pay transparency, there's fines for the first offense between 300 and 600. No, 300 for the first and then 600 for any subsequent. And each posting is an individual violation. So you really have to be careful with it. And, you know, it's interesting. One time I got I had a EEOC charge. This two new entrepreneurs, they put in a posting something like, we're looking for some young blood to, you know, spice up our sales team or something like that. And they didn't necessarily mean young, you know, but it wasn't a very good use of the word. So we settled that one pretty quick. So be careful about what you're posting and the language you use, and don't be too cute when you write something.
All right, Vanessa, what can companies do?
Well, you know, you can take some, you know, surveys. You can look at some collections of surveys, and Melinda, you probably know better than I do what's out there, but you can, you know, look to see what other companies are paying and what are the other benefits being out there. You can do that internal audit that we talked about, do an internal check to see what you're doing, and differentiate that based on not just gender, but the other protected categories that you may have. And then, you know, of course, document any reasons why there's been a discrepancy, and you know, update your job descriptions and job postings so that they really adequately and accurately reflect what's entitled in the job. Update your hiring practices, you know, making sure people understand that there is a range, and your hiring manager can't decide just to throw out a huge number because they really love this employee candidate. And then, of course, training. You know, we talked that, you know, New Jersey doesn't mandate any training, but it really is a best practice to give your HR team, your hiring managers, your supervisor, who's ever like on the front line really needs some training for this, because you will be held responsible for their actions. Okay. How we doing on time? Okay.
I don't know. I was just looking at my watch since operating. Yeah, we're a little behind schedule. That's okay.
Okay.
Hey.
All right. You're up.
Turning over the presentation. So surprise number 3, who knows about New Jersey earned sick leave or paid sick leave? Yeah, so in 2018, the state said that all employers have to provide paid sick leave up to 40 hours of paid sick leave per year to their employees. And it applies to everybody. So even if you hire a summer intern, if they are on your payroll, they get paid sick leave. It's really important to remember, if they're on your payroll, they earn paid sick leave. They accrue 1 hour for every 30 hours worked, up to 40 hours in a benefit year. That benefit year can be defined by you. It can be a calendar year, or it can be based on when the law was originally implemented, which was in October of 2018. So your benefit year might be a little different than a calendar year, but you get to say what your benefit year is. A lot of our clients use a calendar year, which makes sense. You can also choose to you can also choose to front load the time if you wish. So if you don't want to accrue 1 hour for every 30 hours worked, you can say everybody just gets 40 hours. So you can just front load it. You can't require usage. And what's interesting is if they take sick leave, you also can't require a doctor's note unless they've been absent for 3 or more consecutive work shifts or work days. So it's really important to remember. I think we all used to say, if you're absent, you need to come in with a doctor's note to prove you were absent. But now you can't do that unless they're out for 3 or more sick days. They begin earning sick leave immediately upon hire, but you can put in a wait period before employees can use it. That wait period can be up to 120 days. Or you don't have to have a wait period. It could be 60, 90, but not to exceed 120 days. It doesn't need to be paid out of termination, as long as you have a policy that says in writing that it will not be paid out at termination. Sick leave does carry over. And so we'll talk about that in a minute, but it carries over into the next year. However, you don't have to permit anyone to use more than 40 hours in your defined benefit year or benefit period. So it's important to remind employees, it may roll over, but the max you can use in our benefit period is 40 hours. You can determine blackout periods. We have some clients that are very busy at the holidays, and they can set in their policy that they will not permit sick leave. Of course, you can't, that you're gonna frown upon the sick leave, but if they're sick, right? But you can put a blackout period in there. You can require up to 7 days advance notice. Most of our clients put 5 days in, but you can require up to 7 days advance notice. And
I didn't know I was gonna be sick.
I didn't know I was gonna be sick. You know, how are you supposed to know? But sometimes, you know, you can use this for a variety of reasons, which we'll talk about in a minute. So some of it is foreseeable, and that's when you can say, no, we're in our blackout period. And so 5-year record keeping requirement. Remember, the wage theft can go back 6 years, but there's a 5-year record keeping requirement with New Jersey paid sick leave. You have to keep records of time was granted, the time that was taken against it, proof that you rolled over unused time, even if they couldn't use it because they got their 40 hours. And if you're ever audited, you'll be required to produce those records, 5-year record keeping requirement.
This for companies 10 or more, or all companies?
All companies,
You have to have 2 employees.
yep. Anyone on your payroll, all companies,
Is it public and private or just private?
all companies.
Interesting.
So New Jersey sick leave can be used for any of the reasons on the screen here. I'm not going to read them to you because you can all read, but essentially it is for the employee's own health. It is for the health, for them to help care for a loved one who has an illness. It's also for school closures during any sort of academic or public health emergency. It's if their daycare or their school closes. It's also for employees to use it to go to school conferences. So if they have a child, for example, that's having a behavioral issue at school and they need to have a parent-teacher conference, the employee can use sick leave to attend that parent-teacher conference. We already talked about the 3-day rule. Family member. Look at the list of family members this applies to. Grandchild, grandparent. Those are not typical things that we hear. The bottom one. Any person to whom they declare is in a familial type status with them. Their neighbor, for example. If you're close with your neighbor, you can now say, I need sick leave. If you need to care for them. And the rebuttable presumption is back. I love that. So if you take adverse action against an employee within 90 days of them using sick leave, the Department of Labor, if they complain, there is the rebuttable presumption that Vanessa mentioned earlier, that they will automatically assume you have retaliated against them for using that sick leave. And so it's really important that you understand that. And
91 days.
Right, and on the day 91, good luck with that. But like always, you can, if you can show a legitimate reason for the action, then, you obviously could have a potential defense, but that's where, again, we would suggest that if there is a claim and you get a notice from the Department of Labor, that you probably should engage an employment attorney to help you through that sticky mess. And if you have documentation, document, then you're more likely to be able to defend that claim. All right, surprise number 4. This one's a long one because we're including a bunch of things in this. We're going to talk about the New Jersey Family Leave Act, New Jersey Family Leave Insurance, and we're going to talk about temporary disability insurance in this. So the New Jersey Family Leave Act. Those of you who are under 30 employees today, this doesn't apply. However, July 17th, 2026, it's reduced to 15 employees, the threshold. So if you have 15 or more employees starting in July, this will now apply to you. They've also changed the eligibility for employees. They have significantly reduced the requirement for employees. It was 12 months of employment and 1,000 hours. Starting in July, it is 3 months of employment and 250 hours. What does this mean? This means that you will all have to provide 12 weeks of job protected time off for an employee to care for a family member in a 24-month period. So every 2 years, they can get up to 12 weeks of leave to care for a family member. The family member definition, same as sick leave. Everybody plus those you designate as your close familial status. And you can see,
Not 12 weeks of paid, it's just 12 weeks.
we're gonna get there, Frank, we're gonna get there.
Oh.
New Jersey has a law that now pays partial wage replacement for this as well. That's the insurance portion of it. So,
How would employers know all of this? This is unbelievable.
because you come to stuff like this, or you engage an employment attorney, or you call an HR consultant and you have me as phone a friend.
How do you determine, I like, as I listen, I think of all my clients that are business owners and I'm like, they have no clue of it.
No, cool.
They're like, I just look like they're probably flying blind and hoping it just doesn't come up.
And that's what I look a lot when I speak with new potential clients. You don't know what you don't know, right? You're business owners, you're business leaders, you're trying to run a business, which is complicated enough. And how are you supposed to be a subject matter expert, particularly, as I said, in the complicated New Jersey employment laws? So it is extremely difficult, but that's why we're here. And, you know, that's why you can phone a friend and you only pay when you call us, kind of thing. The law drops. Please note that for those of you who had fewer than 10 employees, it goes to 10 in 2027 and to 5 in 2028. This was all passed 3 days before Governor Murphy left office, and so far hasn't been repealed.
So how do we send them a thank you? No. I'm
I'm sure he's unlisted,
Brian.
How do you? Okay, so on the family leave act.
Yes.
I'm sorry, to care for a family member.
Yes.
How do you substantiate that someone needs?
So you can request a doctor's note, for example, that says Tim needs to have time off from work to care for his ill mother. And it's the mother's treating physician that would provide that note.
Employer could request that.
Or if it's their child, right, then they would get information from their child's physician that says, my child, I need to be home to care for my child. Or I need to take every other Tuesday off to take my child to behavioral therapy, or whatever it is. The time can be taken intermittently as well as consecutively. And New Jersey has implemented New Jersey Family Leave Insurance, which is the partial wage replacement component that goes along with the New Jersey Family Leave Act. New Jersey Family Leave Insurance can be taken for baby bonding, or it can be taken also for the care of a loved one. The Family Leave Act may also be taken for baby bonding as well. It pays 85% of the employee's average weekly wage up to a state maximum benefit. 85%. Funded 100% by our payroll contributions. Everyone in New Jersey has a payroll contribution into this fund. And you can receive the benefit for 12 consecutive weeks, which equates to 84 days, or if you're taking it on an intermittent basis, you actually get reduced to 8 weeks or 56 days of intermittent FLI. So the Family Leave Act is the job protection piece. Family Leave Insurance is the partial wage replacement component that goes along with that.
Right. And those of you that are 50 or more, you'll also be subject to the Federal Family Medical Leave Act. And the difference between the New Jersey Family Leave and the federal, apart from the threshold and the hours that you work, but New Jersey's family leave will not apply to the employee's own serious medical condition. Unlike the federal act, they can take, federal family leave if they themselves are sick. So that's, one distinction. Sorry, Melinda, go ahead.
No, that was perfect, Vanessa. Thank you. I think we were going to try to hold questions until the end. If you can just keep a mental note or write it down, just because there's still a lot of material to get through. I apologize for that, but okay. Temporary disability insurance. So effective in July. So everyone's probably familiar with temporary disability insurance. The state of New Jersey actually has a state plan. So you don't need to have a private employer plan. You can refer employees to the state. We have payroll tax contributions into that as well. Temporary disability is for the employee's own health condition, whereas the other law is about caring for a family member or for baby bonding. TDI is for the employee's own health condition. And basically, what happens in July is the connection between temporary disability insurance and the other protected leave laws strengthens, because now what it says is even though you couldn't retaliate against an employee for taking TDI previously, now there's actually a job protection component to TDI starting in July, where you have to restore that employee to their position or a similar position when they are able to return to work. And of course, no adverse impact to the employee. TDI also pays up to 85% of the employee's average weekly wage up to a state maximum. So how do you ensure compliance with this? Make sure that you understand your head count. There's an important component to the New Jersey Family Leave Act. It is based on the total number of employees that you have in the company. So if you have 5 employees in New Jersey and 12 employees in New York, you now have 17 employees according to the New Jersey Family Leave Act. And so at 15 employees, it's going to apply to you. It's not just based on the number you have in New Jersey, it's based on the total number of employees that you have in the company wherever they are. That, don't forget to count your remote employees. If you are letting somebody work from Texas, that person counts. Make sure that you update your policies, your leave, your templates, templates, your forms, all of that, because at 15 employees starting in July, it's going to apply. Make sure you provide the updated notices. In New Jersey, there's actually, you have your labor law posters, right? Posted in a conspicuous place where all employees and candidates for employment can see. But in addition, New Jersey requires that you give new hires some new hire notices that are duplicative of that you have posted, but you're supposed to also give it to them at time of hire. The New Jersey Family Leave Insurance and paid sick leave are 2 of those notices that you're supposed to give at time of hire. So make sure that you're doing that. Get ready to make changes to your leave tracking mechanisms. If any of you use your payroll provider or another third party, make sure that they understand the new requirements of the law, particularly with regard to the decrease in the hours requirement. New Jersey Family Leave Act was 1,000 hours. In July, it's going to be 250 hours. It's a big difference. Train, right? We talk about training. And then be prepared to comply. 12 weeks of job protected time off under the Family Leave Act, 26 weeks for TDI. New Jersey temporary disability insurance can last for 26 weeks. It's probably pretty daunting to those of you who are business owners on the web and also in the room. I can imagine. All right, Vanessa, surprise number 5.
Well, AI, of course, has been exploding lately. Everybody hears it. Everybody wants to use it. It can make us more efficient. It can automate some things, but it also has some, legal risks that attends to it. So the New Jersey Division of Civil Rights and the New Jersey Attorney General's Office recently published guidance on an employer's use of artificial intelligence tools, and it prohibits algorithmic discrimination, which is discrimination that can result from using any type of auto decision tools, resume screenings, for instance. So that if there's technology that is used to automate a part or the whole of any kind of activity that used to require human decision making, it's going to be subject to this guidance, and it's subject to our law against discrimination, our LAD. You cannot discriminate by using AI. So where would this come up, right? So an example that the EEOC gave, there was actually a lawsuit that the EEOC brought up against an online tutoring company, and it had used resume screening, and it screened out, certain resumes, and it found out, by looking at accumulated data, that the candidates who were not hired for tutoring, there was a cutoff for women, anybody aged 45 and older, and for men, it was age like 50 and older, something like that. And so the EEOC found that there was probable cause to believe that there was a discriminatory impact, not intentional discrimination, but the effect of using these tools was to discriminate against older individuals. And so it can be intentional, which would be in discriminatory treatment, or this unintentional part, which is discriminatory impact. And some of the tools you have to be careful because there's going to come with it a accommodation duty. So what does that mean? Sometimes people use video tools to interview candidates. If a person has some type of disability that makes it difficult for them to actually use the video technology, or would present them in a bad light. Maybe you have someone who's got a speech impediment, someone that, has a hearing problem, something like that. You're going to have to accommodate it. And then you're going to have to think about, how does the person's disability impact what would otherwise be, a good candidate if it's going to be disadvantageous. If someone, you do sort of online tests, if someone has a disability and they can't, digitally use the test or whatever it is that they cannot mechanically complete it, that's going to need to be an accommodation. So I put here, how the discrimination can creep into it. It can creep into it in terms of the design by using past hiring practices that predict suitable candidates, training. AI learns from data that's presented to it. So if your data is bad, then you're going to end up with a bad result. And when we talked about the video interviews, if you're using an AI tool to look at the video interviews, if they've screened other interviews and they've learned one particular candidate is a better fit than another, they use that. And of course, how the tool was deployed can also be a place where discrimination can come in. So next slide, Melinda. So it's clear that an employer is going to remain liable for discrimination. You can't pass that buck on to the software designer or the AI tool. That's your responsibility at the core of it. So that's a big burden, just like all the other things we talked about today. Everybody's running here saying, I don't want to hire anybody after this. So, what's your best practice? You have to understand what the tool is. How is it developed? How is it going to look? How is it going to differentiate? How does it substitute for my human decision making? And, I wouldn't understand all that. So if I was doing this, I'd have somebody from my IT team help me with understanding what this is. You can conduct some bias audits pre and post deployment. So if you're going to use something, test it out. And then your first run, test it out. Has it discriminated on any protected characteristic? And then you should be providing notice to candidates that you're going to be using AI at some point in time. There is some pending legislation in New Jersey that would regulate the use of AI tools. I know there's an executive order that says all of the regulation for AI is going to come out on a federal level. Well, most states are not following that. They're doing what they think is best for their states, state employers. And then there's another potential legislation that's out there that would require AI to analyze applicant videos to follow specific procedural requirements. So there's things pending out there, but the guidance is available, and it is something worthwhile taking a look at. If anybody wants that, they can email Melinda or I, and we can send that out. So the bottom line is do your homework. Ignorance is not going to be your defense here, and you're not going to be able to pass the buck. You may want to think about it when you hire people. When you use a service provider, maybe you're going to build in some contractual language to minimize your risk, but that won't get you over a lawsuit, with the EEOC or the New Jersey Division of Civil Rights or an individual if they feel that there's been bias used.
So I think we were going to get into some hypos, but I'm thinking maybe we just get into some questions. Vanessa, I don't know if there's questions online that you would like, that you want to go through. I know there are some questions in the room.
I haven't seen any through the chat, but if you do have questions, please put them in. Now's your time. So go ahead, Melinda. Go ahead.
Okay. And I just want to make sure that the disclaimer gets up, because this is not considered legal advice, right? This is informational purposes. And then CNA Financial, of course, has a disclaimer as well. They're not providing advice either. They're giving you information to try to help you in your business management. So just want to make sure I covered that.
Yes, good job. Good job.
And our contact information is here. So if you want to jot down our contact information, you can reach out to us that way, but, what would you like to ask? Yeah, you had your hand raised.
For the New Jersey Family Leave Act and the Disability Act, like how does that impact commission-based employees?
So-
Salaries.
Right, so it does actually take a look at all of their wages earned, and it will pay 85%, but only up to the state maximum.
Okay.
So, but it will be considered,
What
as,
is the state maximum?
right now, I believe it's around $1,085 a week.
Right.
So it looks
So
like
it's not going to pay 85% of the most highly compensated person, you know,
Correct.
they will get cut off. But for a lot of, you know, people that sort of meet that mid-range, it's not a bad paycheck.
Right,
Talk about disability and family leave insurance, are they both paying at $10.85 a week in New Jersey?
correct.
Yeah.
Yeah, it's 85% up to that state maximum, which is around $1,085 right now. Yes, please, in the back.
Can you guys discuss the Retire Ready New Jersey program? I know that it came down from like 25 to 10. Is it fully enforced for 2026?
Retire Ready, Vanessa. So it's part of Secure Act 2.0. I don't know how well versed you are with that off the top of your head.
Yeah, no, I don't think I can comment on that, but if
Well,
you
we can
want to
certainly-
leave your name, we can email you back on that one. So,
Yeah. Yeah, it was requiring, like you said, employers with 25 or more employees who didn't already have a retirement plan in place to provide one, but that threshold has dropped. But unfortunately, I can't speak intelligently about it without doing more research into it as well. I apologize for that, but we can get you information, certainly.
So that, New Jersey Transparency 2025,
Yes, Pay Transparency 2025.
I take it came out last year.
It did.
And so is there then a database that all this is kept in?
So Pay Transparency is completely up to your business and what you set for the positions in
So
your
it's not
business.
that you have to send in the information to the state and there's some state,
No,
you know, that somebody can just go and say, what's this company?
no, not at all. People could go on whatever job postings you have and they could see what you're paying, what the range is for the position. But the
Right.
state is not collecting the information. Vanessa, go ahead.
I was going to say the state doesn't require that you pay in a particular range. We haven't gotten to that point in time, other than your, you know, minimum wage. So you set your ranges, and you offer what benefits you think are appropriate, you know, subject to.
Client has to be putting out into some database somewhere.
It's not public information in that the state is collecting it and providing it in a report, but it is public in that you're putting it on job ads that are on public places like Indeed or on LinkedIn or wherever
Right.
you're put. So
And-
the
and the-
benefits, all
Go
that.
ahead. And those databases, you know, they may compile that information for benchmarking and something, you know, who's ever going to do the benchmarking company can do that. So,
My picture so long. Please.
I have two questions. If somebody is taking 12 weeks baby bonding and they decide to split it up, is what they're saying is they're still entitled to the 12 weeks. If they do split it up intermittently, then they'll only pay for 8.
That's correct. So family leave insurance will only pay for up to 12 weeks of leave if taken consecutively or 8 weeks if taken intermittently. The other thing about the baby bonding, and that was a very good point, is baby bonding has to be taken within 1 year of the birth or adoption of the child.
mhm.
So they can't in year 2 say, I now want to bond with my 2-year-old. Okay,
And then my second question is if companies are using job boards and the job board company, ZipRecruiter, Indeed, was using AI to filter based on your job posting that says, hey, great match, and you reach out to them, not
Mhm.
realizing that their filters with AI.
Yeah.
And all of a sudden, you don't realize like, wait a second, like, at the end of the day, it's like, oh, they're only giving me people within this age range or from this location or whatever. Is the employer still liable for that?
Vanessa, do you want me to repeat that?
No, I did hear it. I think
Okay.
I think there is a potential you could be, because you can't pass it to the vendor. And so if you're only receiving the resumes where it says great match, then you are selecting against those that didn't match. And if there's a difference in terms of race or age or gender, that could be a problem for you. So it would be important to know.
Yeah,
Yeah.
don't limit yourself to just the great match people.
Yeah, I think that, it would behoove you to say, how do they come up with this and the data and that kind of thing. So I think you have to be careful with it. You really do. So, because that, in other words, you are using that service to screen your resumes for you. And so I think you would potentially be subject to it if there's a discriminatory impact. So. And again, it's not, and it's based on those protected characteristics. So, yeah.
And in New Jersey, it's based on the New Jersey protected characteristics, not just Title VII federal.
Right.
One of the other things that I talked about how New Jersey requires certain new hire notices. Also in New Jersey, in 2023, the state amended the unemployment insurance law. And they said that now all terminations need to be reported to the state. They put the law in effect in 2023, but the tool to actually report those terminations wasn't available until December of 2025, but it is now available. So you are supposed to be reporting all terminations, no matter the reason, whether they resigned or you terminated the employment relationship, to the state of New Jersey Unemployment Insurance Office. And what it's going to do is it's going to ask you a couple of questions. What was the reason for the separation, that sort of thing. And then that way, the Unemployment Insurance Office, what they're trying to do is prevent fraudulent claims, or they're trying to prevent paying people who shouldn't be getting unemployment. And so this is now a new law. It's required of every employer. Well, the law passed in 2023, but the tool is now available. So we want to make sure that everybody is aware of that requirement as well.
And that's definitely, an area of frustration for those of us that practice and for employers, is that New Jersey rolls out rules and it doesn't always give you either the guidance or the tool to actually implement it. That's what happened when we got, paid sick leave. All of us were scratching our heads going, what the heck are we supposed to do to that?
Paid sick leave law went into effect in October of 2018 and the regulation was published in January of 2019. So we had 4 months of flying blind, but that's okay.
Yeah,
we figure it out. What else? Is there anything online?
No, my online people are very quiet. I know you're still out there because I can see that you're still there, but they've been quiet.
I've got one last question.
Okay, one last question
From me.
Okay.
So if we have clients that own businesses, and my guess is many of them don't have any clue of the depth of this information. How do you work, or people like yourself, do they retain HR consultants such as yourself?
Mm-hmm.
Or is it that, they don't know what to ask? So is it like, do they just outsource that HR part? Because I know you don't do benefits, you don't do things like that, so it doesn't compete with things that we do.
Right.
But the other side of that is, how do they know what they don't know?
Right.
So they don't get in trouble.
Yeah. So we do engage on an hourly basis, and we ask a lot of questions, right? We ask them, do you have a handbook? Can we see your handbook? We go through the handbook and we say, there's nothing in your handbook about the New Jersey Family Leave Act. There's nothing in your handbook about the New Jersey Earned Sick Leave. Are you doing that? Right? We just ask a lot of questions. And then that tends to flush things out. I had a new client recently engage with me, and he started talking about how he has a lot of 1099 employees. I'm using air quotes as I say that to those of you if you can't see me. And we started talking about the New Jersey requirement for 1099 independent contractors, the federal requirement and all of that. And we really tried to help him understand what might be appropriate use of a 1099 and what might not be. And so it's just, we ask a lot of questions. So you have to deal with us asking you a lot of questions and then think these things surface, and then we help you figure out how to get in compliance if you're not already with it.
What do you say, help them get in compliance? It's not that they can't just write you a check and you did it for them.
So we have policies and we will help, you with the rollout of these things. Also, as an HR professional, I know where my limit is, and when I need to tell you, look, you really should engage an employment attorney to help you with this.
Yeah.
And because HR Advantage Advisory is a wholly owned subsidiary of the Clark Hill Law Firm, we have over 90 employment attorneys around the country and globally. Employment attorneys that we can work with. Vanessa and I work most closely because she is licensed in New York and New Jersey. But the law firm itself is a full service law firm with over 850 attorneys globally. So there, even if it's not HR related, the firm can help. One more question.
I guess then my last question, so I guess there are differences in how these laws are applied for like W-2 versus statutory versus 1099 contractors.
That's correct. Yeah. For example, New Jersey earned sick leave does not apply to 1099 independent contractors. Vanessa, what else would you add to that? As we
Just
wrap
that,
up?
you know, it's very tough to be an independent contractor in New Jersey. You really have to follow some very stringent tests. So be judicious with using that designation. And if you have questions, you know, please reach out to your HR professional or, you know, counsel, because New Jersey really presumes everybody is an employee, not an independent contractor, and you have to prove it otherwise. So
There's also a required poster for 1099 independent contractors as well in the labor employment
And
poster.
I know I said, I was in this. But you represent the employers,
Correct.
Right.
not the employees. So, and the reason why I bring that up is because every once in a while, we'll have an individual client that thinks that they were wrongfully dismissed somewhere.
Right.
And so when they're looking for someone to represent them, that's not your client.
That is
Your
not
client
us.
is the business. So everybody knows.
Right.
Just wanted to make sure everybody knows that, because we have clients on both sides. We've got the business owners, and we have the individuals. So when your individual says, I'm looking for a labor attorney, don't bother them for that.
Not Vanessa.
For your business owners,
Go ahead.
you want to make sure that they know that they exist, because it's important.
Right. And I am a certified human resources professional with over 25 years of experience in HR, but Vanessa is the employment attorney with over 30 years of experience in employment law. And so we work very closely together on many an occasion, because sometimes you don't need an attorney, and sometimes you can't just have an HR person. Sometimes you do need the attorney.
right. And we're pretty creative of how we can help employers, you know, solve their particular problem. There are times we sort of pair up together. One of the big ones we pair up together is if a client has had a Department of Labor wage audit or investigation. You know, we work really closely on that together. And you can bother me if you need a referral for an employee side attorney. I know a bunch of very good employee attorneys. So if your client calls you and says, you know, I really need a referral, I can usually give you a couple names and you can figure it out. So you
What
can
about
bother me
the-
with anything, basically.
Vanessa's very active in the American Bar Association, so she knows a lot of attorneys around the country and globally. I think we truly have one last question.
Very quickly, will this information be available if we want to share with some of our clients that are business owners?
Adina's shaking her head in the back.
Yeah, this is being recorded, so yes.
And, you know, Melinda and I talked about what to do next, because this is pretty high level. You know, you're certainly not going to be an employment law or HR expert after, you know, an hour here. So we were thinking we would roll out sort of a series that might be more nuts and bolts, like, you know, here's your hiring 101 or best practices, here's your firing 101, you know, that kind of thing. So stay tuned.
Leave of absence management is a big area that a lot of employers
Absolutely.
don't know what to do. Yeah.
Right.
So
So
thank you all. Thank you though, for those of you who are online. Thank you all. We really appreciate the opportunity given to us today.
Thank you so much.
Thank you.
thank you so much.